Rules on appeal, revision, review and power of appellate court. Question. Discuss appeal and revision as mentioned in the Code of Civil Procedure 1908. Answer. What is appeal? Any aggrieved party can file an appeal against the order of a lower court for the dismissal, amendment or judicial review of the order before a higher court. Number 1. Appeal should be filed in the form of memorandum, Order 41, Rule 1. Number 2. Every appeal shall be signed by the appellant or his advocate, Order 41, Rule 1. Number 3. A copy of the decree or order shall be submitted with each memorandum, Order 41, Rule 1. Number 4. The appellant shall not accept by leave of the court, urge or be heard in support of any ground of objection not set forth in the memorandum of appeal, but the appellate court in deciding the appeal shall not be confined to the grounds of objection set forth in the memorandum of appeal or taken by the leave of court under this rule, Order 41, Rule 2. Number 5. If there is no provision of appeal in law, no appeal can be filed. Appeal may be filed, number 1, against the original decree, sections 96 to 99. Number 2, appeal from order, sections 104 to 106, Order 43. Who can file an appeal? Number 1, any person or his legal representative aggrieved by the decree. Number 2, any interested person with the leave of the court. Number 3, in case of minor, his legal representative. When shall an appeal not lie? Against a compromise decree, section 96, subsection 1. Against a decree of a small cause court. Against a decree under section 9 of the Specific Relief Act. If no appeal is made from the preliminary decree. According to section 97 of the Code of Civil Procedure, if no appeal is made against the preliminary decree, appeal shall not lie against the final decree. Powers of the Appellate Court. According to section 107 of the Code of Civil Procedure, the Appellate Court has power to number A, to determine a case finally. Number B, to remand a case. Number 3, to frame issues and refer them for trial. Number D, to take additional evidence or to require such evidence to be taken. Adjournment in appeal. According to Rule 12A of Order 41, the Appellate Court shall not grant more than 3 adjournments for hearing of an appeal at the instance of either party to the appeal, and any adjournment granted to a party beyond the aforesaid limit shall make such party liable to pay such cost which shall not be less than 200 taka and more than 1000 taka to the other party as the court may deem appropriate and determine. And non-compliance with which by the appellant shall render the appeal liable to be dismissed, and by the respondent shall render the appeal liable to be disposed of ex parte. An appeal dismissed or disposed of ex parte under sub-rule 1 shall not be revived for hearing unless the party for whose non-compliance the appeal was dismissed or disposed of ex parte makes within 30 days of such dismissal or ex parte disposal an application to the court for such revival, and upon such application being made, the court shall award such cost as shall not be less than 200 taka and more than 1000 taka as it may deem appropriate and determine. Hearing of appeal. According to Rule 16 to 22 of Order 41, on the day fixed or on any day, on any other day to which the hearing may be adjourned, the appellant shall be heard in support of the appeal. Where on the day fixed or on any day any another day to which the hearing may be adjourned, the appellant does not appear when the appeal is called on for hearing, the court may make an order that the appeal be dismissed. Where the defendant is absent, the court may decide ex parte. Upon hearing, respondent may object to decree as if he had preferred separate appeal. Remedy for the appellant. If an appeal is dismissed, the remedy is provided in Rule 19 and 19A of Order 41. Where an appeal is dismissed under Rule 11, Sub-Rule 2, or Rule 15A, or Rule 17 or Rule 18, the appellant may apply to the appellate court for the readmission of the appeal. And where it is proved that he was prevented by any sufficient cause for appearing when the appeal was called on for hearing, or from depositing the sum so required, the court shall readmit the appeal on such terms as to cost or otherwise as it thinks fit. Notwithstanding anything contained in Rule 19 or any other rule, the court may, in order to avoid delay and expedite disposal, directly readmit without requiring the appellant to adduce evidence to satisfy it about sufficient causes as required under Rule 19. The appeal under this rule shall not be readmitted unless an application supported by affidavit praying for such readmission is made to the court within 30 days of the date on which the appeal is dismissed or dismissed for default. Provided further that no appeal shall be admitted more than once under this rule. Remedy for the respondent. Where an appeal is heard ex parte and the judgment is pronounced against the respondent, he may apply to the appellate court to rehear the appeal, Rule 21, Order 41. Notwithstanding anything contained in Rule 21 or any other law, the court may, in order to avoid delay and expedite disposal, directly rehear an appeal which is heard ex parte without requiring the respondent to adduce evidence to satisfy it about sufficient causes as required under Rule 21, but requiring him to pay such cost not exceeding 3,000 taka as it may deem appropriate and determined. Rule 21A, Order 41. What is revision? Revision means the amendment of judicial remedy by the higher court in a decree or order issued by the lower court. Section 115, that is 115 of the Civil Procedure Code, deals with the provisions relating to revision. Who shall apply for revision? Any aggrieved party by the decree or order shall apply for revision. Where to file a revision? Revision is to filed before a higher court. The courts having revisional powers are the district judge and the High Court division. Conditions as to revision. Number 1, a lower court has passed the order or decree not appealable. There is an error in important question of law occasioning failure of justice. When revision is to be filed before the High Court division. According to Section 115, subsection 1, the High Court division may, on the application of any party aggrieved, call for the record of any suit or proceedings in which a decree or an order has been passed by a court of district judge or additional district judge, or a decree has been passed by a court of joint district judge, senior assistant judge or assistant judge, from which no appeal lies, and if such court appears to have committed any error of law resulting in an error in such decree or order occasioning failure of justice, the High Court Division may revise such decree or order and make such order in the suit or proceedings as it thinks fit. When revision is to be filed before the district judge, according to section 115 subsection 2, the court of district judge may, on the application of any party aggrieved, call for the record of any suit or proceeding in which an order has been passed by a court of joint district judge, a senior assistant judge or assistant judge, from which no appeal lies, and if such court appears to have committed any error of law resulting in an error in such order occasioning failure of justice, the court of district judge may revise such order and make such order as it thinks fit. What is second revision? According to section 115 subsection 4, a second revision can be filed against the order of the district judge or additional district judge before the High Court Division. Question: can an appeal be filed against the order of the appellate court? If so, when? Discuss with relevant provisions. Answer: generally, in civil cases, a second appeal cannot be filed against the decision of an appellate court. This is because the provision for filing a second appeal has been cancelled from the Civil Procedure Code. However, appeals can be filed against certain decisions of the appellate court. For example, if the appellate court does not approve the application for re-appeal under Rule 19 of Order 41, and if the Court of Appeal does not approve the application for re-appeal hearing under Rule 21, an appeal can be filed against that order. Question: in which cases a review can be filed? Discuss. Answer: in which cases a review can be filed? Generally, a review means to reconsider a judicial review of an order by the same court. Section 114 of the Civil Procedure Code and Order 46 discuss the provisions relating to reviews. As per Rule 3 of Order 46, the application form will also be used for review application. When an application for review can be made, according to Order 47, Rule 1 of the Code of Civil Procedure, any person considering himself aggrieved may apply for review of judgment where number by a decree or order from which an appeal is allowed but from which no appeal has been preferred. Number B, by a decree or order from which no appeal is allowed, or number C, by a decision on a reference from a court of small causes. Question: appeal is the continuation of the original suit. Discuss briefly. Discuss the powers and the functions of the appellate court. Do you think that appeal lies against any decree? Answer: appeal is the continuation of the original suit. The case is the proceeding for final decision of the court to resolve the dispute between the plaintiff and the defendant on a matter of judgment. When a court gives a judgment, it is final for the court. But if a person is aggrieved by a decision of the trial court, he can appeal to the High Court. Then the decision given in the appeal is the final decision of the case. In fact, this is why it is said that appeal is the continuation of the original case. In the case of Azad versus Mustafizur Rahman, 16 BLC AD, the Appellate Division said that the appeal is a continuation of the original case. The Court of Appeal, like the trial court, may exercise all powers like trial court. The appellate court can dispose of both legal and factual questions. From the discussion, we can say that the appeal is a continuation of the original case. The decision of the lower court is not the final decision or conclusion of any case. If an appeal is made against it, the decision of the appellate court is final. Even the decisions of the appellate court on appeal is sent back to the judicial court for enforcement, as the decision of the appellate court has to be issued as a judgment of the trial court. Thus, appeal is the continuation of the original case. Powers of the appellate court. According to section 107 of the Code of Civil Procedure, the powers of the appellate court is, number one, subject to such conditions and limitations as may be prescribed, an appellate court shall have power, number A, to determine a case finally, number B, to remand a case, number C, to frame issues and refer them for trial, number D, to make additional evidence or to require such evidence to be taken. Number two, subject as aforesaid, the appellate court shall have the same power and shall perform as nearly as may be the same duties as are conferred and imposed by this court on courts of original jurisdiction in respect of suits instituted therein. Court may conclusively determine the suit. According to Rule 24 of Order 41 of the Code of Civil Procedure, where the evidence upon the record is sufficient to enable the appellate court to pronounce judgment, the appellate court may, after resettling the issues, if necessary, finally determine the suit, notwithstanding that the judgment of the court from whose decree the appeal is preferred has proceeded wholly upon some ground other than that on which the appellate court proceeds. To remand the lower court by the appellate court. To remand to the lower court by the appellate court. According to section 107, the appellate court has the jurisdiction to remand the case. According to Rule 23 of Order 41, where the court from whose decree an appeal is preferred has disposed of the suit upon a preliminary point and the decree is reversed in appeal, the appellate court may, if it thinks fit, by order remand the case and may further direct what issue or issues shall be tried in the case so remanded, and shall send a copy of its judgment and order to the court from whose decree the appeal is preferred, with directions to readmit the suit under the original number in the register of civil suits, and proceed to determine the suit and the evidence, if any, recorded during the original trial shall, subject to all just exceptions, be evidence during the trial after remand. Where the appellate court can frame issue and send those for trial. According to Rule 25 of Order 41, where the court from whose decree and the appeal is preferred has omitted to frame or any issue or to determine any question of fact which appears to the appellate court essential to the right decision of the suit upon the merits, the appellate court may, if necessary, frame issues and refer the same for trial to the court from whose decree the appeal is preferred, and such case shall direct such court to take the additional evidence required, and such court shall proceed to try such issue and shall return the evidence to the appellate court together with the findings thereon and the reasons therefor. Where the appellate court can take additional evidence. According to Rule 27 of Order 41, the parties to an appeal shall not be entitled to produce additional evidence, whether oral or documentary, in the appellate court. But if number A, the court from whose decree the appeal is preferred has refused to admit evidence which ought to have admitted, or number B, the appellate court requires any document to be produced or any witness to be examined to enable it to pronounce judgment, or for any other substantial cause, the appellate court may allow such evidence or document to be produced or witness to be examined. Number 2, wherever additional evidence is allowed to be produced by an appellate court, the court shall record the reason of its admission. Procedure of taking additional evidence. According to Rule 28 of Order 41, taking additional evidence, wherever additional evidence is allowed to be produced, the appellate court may either take such evidence or direct the court from whose decrees the appeal is preferred, or any other subordinate court to take such evidence and to send it when taken to the appellate court. When shall an appeal not lie against a compromise decree, section 96 subsection 1, against a decree of the small cause court, against a decree under section 9 of the specific relief act. Thank you, viewers.